Now, voting to overturn federal legislation, to me at least, seems to be one definition of what people understand as judicial activism. But I want to talk about some cases that I've seen that I think show judicial activism functioning on a more pernicious level. First, let's take a look at a case called Gross v. FBL Financial Services that the Supreme Court issued last month. Are you familiar with that?
I am.
Okay. Now, Gross involved the Age Discrimination in Employment Act, or ADEA. And now, before Gross, you could bring an age discrimination suit whenever you could show that age was one of the factors an employer considered in choosing to fire you. When the Supreme Court agreed to hear the case, it said it would consider just one question: whether you needed direct evidence of age discrimination to bring this kind of lawsuit or whether indirect evidence would suffice. That's the issue that they said that they would consider when they took the case. But when the Supreme Court handed down its decision, it ruled on a much larger matter: whether a worker could bring a suit under ADEA if age was only one of several reasons for being demoted or fired. The Supreme Court barred these suits, saying that only suits alleging that age was the determinative factor for the firing, only those could be brought under the ADEA. This change has significantly eroded workers' rights by making it much harder for workers to defend themselves from age discrimination, including getting fired just before they would have seen a large increase in their pension. You weren't fired for you're too old, you're fired because your pension is going to increase soon. So this is a big deal. When you go to court to defend your rights, you have to know what rights you're defending. The parties in the Gross case thought they were talking about what kind of evidence was necessary in a discrimination suit. Then the court just said, no, we're banning that kind of suit altogether. I think that's unfair to everyone involved. It's especially unfair to the man who is trying to bring the discrimination suit. So let me ask you a couple questions on this. First, as an appellate court judge, how often have you decided a case on an argument or a question that the parties have not briefed?
I don't think I have, because to the extent that the parties have not raised an issue and the circuit court, for some reason, the panel has thought that it was pertinent, most often that happens on questions of jurisdiction. Can the court hear this case at all? Then you issue, or we have issued, a direction to the parties to brief that question. So it is briefed and part of the argument that's raised. There are issues that the parties brief that that the briefing itself raises the issue for the court to consider. So it's generally the practice, at least on the Second Circuit, is to give a party an opportunity to be heard on a question. And we also have a procedure on the circuit that would give a party to be heard, because they can also file the petition for rehearing, which is the panel enters a decision that the party disagrees with and thinks the court has not given it an adequate opportunity to present its arguments. Well, then it can file that at the circuit. I don't have, I am familiar with the Northwest case. I am familiar with the holding of that case. I'm a little less familiar and didn't pay as much attention to the briefing issue. I do know there that, like the Brand X case, what the court says it was attempting to do is to discern what Congress's intent was under the ADA, whether intended to consider mixed motive or not as a factor in applying the statute. And the majority holding, as I understood it, was, look, Congress amended Title VII to set forth the mixed motive framework and directed the courts to apply that framework in the future. But having amended that, it didn't apply that amendment to the age discrimination statute. And so that would end up in a similar situation to the Brand X case, which is to the extent that Congress determines that it does want mixed motive to be a part of that analysis, that it would have the opportunity and does have the opportunity to do what it did in Title VII, which is to amend the act.
Well, in Title VII, they amended the act because they had to. They were forced to, right? Congress was impelled to, in a sense, but not on ADEA.
I don't like characterizing the reasons for why Congress acts.
Okay, I got you.